Good afternoon, ladies and gentlemen. All right, so I know persons are still filtering into the room, but thank you for joining us here today. We'll get started in a minute, but do want to welcome you all to today's webinar session on From Privacy Training to Implementation. And this topic has been particularly important right now because we do want to talk about the approach to not only understanding what your privacy requirements are and the theory around privacy, which some of you, most of you would have learned in your certified privacy training, but how do you actually apply that and get your program moving today? So I do believe there will be some time for questions and answers towards the end, but I'll go ahead and get started, and I know more and more persons will continue to filter into the room. If you're having any issues hearing me, then please, indicate the same so that we can have those things corrected. But thank you again for joining. My name is Stuart Hilton, Senior Manager for IT Compliance and Data Privacy here at Symptai Consulting Limited. I myself have done the CIPT and the CIPM certifications, and I'm certified. I have done the CIPP training and may have sat in a class with a couple of persons on this call. But do want to do a quick recap on those items, and I myself plan to sit that CIPP exam at some point. For anybody who hasn't done theirs as yet, if you haven't, there's still time. You can go ahead and continue to work with Symptai Consulting Limited to get you across that line and get you certified, so that you're in the right position to help your organization move forward. So a quick recap. If you've done any of these trainings and you've done any of these certifications, then you know what they are. But for anybody who hasn't done one or two of them already, then here you go. The Certified Information Privacy Professional, which is really the legal aspects of data privacy and protection. So this particular certification really is covering off on understanding privacy law. So you get a good understanding of what are the different legislations around the world, some of the more pertinent ones especially, and get a good understanding of how to address things like the lawful basis for collecting and processing information. So anybody, and if you're not on the same page as me in terms of understanding of those requirements within the CIPP, then let me know. We'll see if we covered off on the material correctly. The CIPM, and I think this is one of the more popular certifications because it is really addressing how do we operationalize a privacy program. And the important thing about a privacy program is it's there to get you towards your goal of becoming compliant with the privacy legislation, whether it's here in Jamaica, whether it's in Barbados, Cayman, wherever you are in the world. It's not tied to any particular legislation, but it's there to recognize what you need, how to move forward, and what are some of the structures you can use to really get your programs cemented into your organization. And then the final one, CIPT, Certified Information Privacy Technologist, is really about incorporating data privacy into all your solutions, processes, procedures. So it's that technical aspect to help integrate privacy in everything we do at its core from the get-go and not as an afterthought. So I can definitely speak to the CIPT and the CIPM as those certifications that really do help you incorporate privacy into your practices. So why are we here today? We want to, of course, take what are some of those theories and some of those lessons learned from the certifications, and we want to move forward with our organization. We want to get to a point now where our privacy program is operationalized. So let's figure out, how ready are you today? Where is your organization today on its privacy journey? And how much further do we have to go? If you're in Jamaica, our deadline is November 30th, 2023 to get up and running so that we can register with the Office of the Information Commissioner. Number two is, how do we move forward? Wherever you are, if you're kind of at a stopping point or if you're not sure where to go, let's figure out how do we move things forward and how do we get to the next step. And then number three, of course, are the immediate next steps. What are some of the things that you can do immediately after this webinar to get your organization on the right path? We'll start off with verifying that some of these items have been addressed. So, pay particular attention to what we're going to discuss on the next few slides, because, I do have a quick poll to find out, how mature do you think your organization is in meeting these goals? So we'll talk about data privacy and protection in these 4 categories. One, accountability and governance. So, has ownership been assigned? Do we have a clear path forward? Number 2, the lawful basis and transparency, meaning, of course, have we fully captured all of the data that we have in-house? Do we understand what the legal basis or the lawful basis is for us collecting and processing that data? And are we being transparent with our data subjects? 3, data security, which are the technical aspects of protecting our data. And then number 4, do we have the processes necessary to support the enactment of data subject rights? So we're going to talk about these items. And if you like, I know we're going to share these slides after the presentation, but if you like, you can treat this almost like a quick cheat sheet or a quick checklist. So if you go back to your organization after this webinar and you can go through these items and say, do we have this? Do we have this? And if we're saying no, then that means we have something that needs to be addressed. And not to say that this is completely extensive of what you need to put in place, but it's a good basis for checking how far along you are. So accountability and governance, as I mentioned, 1, we assign someone to lead the privacy protection journey. So, there's somebody who owns it. I'm not saying it has to be in any one particular department, but you do want to have a clear leader in this area. One of the leading groups that tend to lead in this effort based on the annual survey conducted by EY and the IAPP says that privacy tends to report into legal and compliance. Not saying that's where you have to go, but it's one of the areas that tend to cover it the most. Of course, you do have instances where privacy reports directly into the CEO, may report into HR or IT, but this is just operationalizing and managing our program. Number 2, we have appointed a data protection officer. Now, I'm sure a lot of people will say no at this point because we're still trying to figure out whether we need a data protection officer and what are the requirements for picking one. But if you have, great, check the box. Data protection is included in all 30 processor and joint controller agreements. So we're clear about what our responsibilities are on both sides of the coin, with our third parties, with our joint controllers, and we have agreements that stipulate whose responsibility is what aspects of the legislation. 4, a data privacy and protection framework has been implemented for continued management of data privacy and protection. Now, while this one isn't a requirement in the legislation, it really is there to help us to maintain compliance. So we have it as a part of our operations. Data privacy and protection objectives have been communicated across the company. So not just the leaders, not just the persons who may be working on this on a day-to-day basis, but everybody in the organization understands what our strategic direction is when it comes to data privacy and protection. All employees have been trained and are provided with ongoing awareness. So again, I just ask you guys, you can do a mental check for the ones that you can say, yes, we've done this. And the ones that we haven't, you can put an X and we'll keep track of those. Lawful basis and transparency. So 1, we have a clear understanding of what information we need and how it's used. And of course, a great way to verify that we've done this is that we've developed what's called a record of processing activities, which says, here's all the data we have, and here's the lawful basis for why we use it. And we have a clear understanding of where it's used in our business. And for anything that we aren't sure about, we'll start a process of removing it. Number 2, we have lawful basis for the collection and processing of personal data. Can we check that off and say, we have documented this. So whenever we come to collect demographic information from employees, this is the reason why we do that. Sorry, just taking a quick chat, okay? Number 3, we have a transparent process for communicating our processing activities to data subjects. And for all the persons who have done the training, which I know you remember, that is part of your privacy notice. The internal document is our privacy policy, and the document that faces our data subjects and even our employees will be that privacy notice to provide a transparent means of communicating what we use the data for and what should the data subject expect of us. And 4th, we can demonstrate how data subject consent was or is obtained. Because remember, there comes a day that we get asked, did you get consent from this individual on how you're using their data? We should have a way of being able to show that this was obtained freely and fairly. On to data security. One, data protection measures have been implemented throughout the data lifecycle. So from the point of origination all the way through to destruction. In all of that process, wherever the data originates, all the way through to where it's stored or destroyed, we have a means of protecting it, and we can validate those things. Data is encrypted, anonymized, or pseudo-anonymized where possible. Number two, an information security management system or program is in place to continuously improve data protection measures. And a lot of persons will be familiar with standards like ISO 27001, which is the ISO standard for information security management system. Of course, you may use another approach, and that's fine. NIST has a great cybersecurity framework, but the point is we have a process for managing our cyber or our technical controls and making sure it's continuously improving, because the hacking mechanisms or the ways that people attack us, those are continuously improving and getting harder to defend against. So we have to continuously improve our mechanisms to protect against those. A data protection impact assessment has been performed, and privacy impact assessments are performed as needed. And remember, the DPIA, or the Data Protection Impact Assessment, is that document or that assessment that we shall include as a part of our registration, as well as a part of our annual submission to the Office of the Information Commissioner. Number four, processes are in place to detect data breaches and notify the supervisory authority and data subjects in a timely manner. So do we have a mechanism for knowing when it's a breach versus an incident, and that we can notify the relevant persons within that 72-hour time limit that we have? So the moment we've identified a breach, do we have a way of ensuring that we notify the data subject and the information commissioner within 72 hours, or are we going to sit on it until we really figure out everything else about it? And lastly, data protection measures have been rigorously tested, and we can validate the robustness of our controls. Now, one of the most surefire ways to kind of test out your system is to have a third party do an assessment, an independent assessment, to see if your network, if your programs, all applications can stand up to the test of a third party who has good experience in doing these things. Alternatively, this is not, of course, because that's not going to be an easy thing to do for a lot of companies, is you could have, if you have an in-house IT person or information security person, that's even better, then have that person sit independently of the operations for a bit to test them themselves and say, we've used a good framework such as OWASP or going through the ISO requirements, and we've tested whether our systems can stand up to an external attack. There may be some gaps, that's to be expected, but the point is we've tested it, we know what our gaps are, and we're addressing those on an ongoing basis. So again, you can check out those items that you have done. And lastly, privacy rights. And I know everyone is familiar with the 6 privacy rights outlined in the Jamaican Data Protection Act. And this may vary depending on where you are, because GDPR, I believe, has about 8 privacy rights. And that's because it includes, like, I know one item is the right for erasure, or the right to be forgotten. That's not explicitly outlined in our legislation, but may apply. But let's talk about what's here, and we can check to see if we have this in place. We have a process to provide data subjects access to their personal data, yes or no. We have a process to manage data subject consent, meaning that if a data subject gave us consent, we have a way to remove it later if they so choose, and where it's applicable, and we have a means to gather new consent if that changes in the future. We have a process to prevent direct marketing. We have a process for responding to data subjects about automated decisions, if automated decisions are in your organization. We have a process to rectify inaccurate personal data. And lastly, we have a process to stop processing personal data if asked, wherever applicable, because not every instance is going to be applicable. So we're going to have a quick poll based on those items we've checked, where we've checked yes or no, and this is not an exact science. We're going to launch a quick poll just to see how ready do you think you are based on those items that we've gone through. I know my handy supervisor will drop that in. Yes, great. So the poll is up, and I'll just ask everybody to take a guesstimate as to where you fall. Do you think most of those things that we spoke about are in place? You think none of them are in place? Go ahead and respond to that poll. All right, and the poll has been closed. All right, so this is interesting because we're coming into what I consider like the final stretch to be ready. We're within that, just about 1 year left to get ready and register. And the majority of respondents, about 66%, are below 50%, meaning that we're at 66% of persons are saying we're not really ready. And that's fine. It's not to say that we're, by any means, near a detrimental period. But the point is that means that we have quite a bit of work to do in the next year. I'm going to talk about the approach to doing that next up. All right, but thank you all for responding. So what I'm going to provide you with here is actually, part of the approach that I take in assisting companies to go ahead and start understanding where they are today in detail and to help support the implementation process. So let's talk about that. At a high level, we start with our current state assessment. So that's, what I call stage one, where we make sure to understand what are the requirements for your environment and what are the gaps in order to then develop what is a remediation plan or implementation roadmap to get you there. And that is a key artifact coming out of that stage one current state assessment, because that's going to drive our activities towards implementation, because we now identified what are the critical things we need to do, what are the things that we're doing in our environment that sometimes we find out we didn't know that we're doing that. So it's good to do that initial current state assessment to then drive your implementation, because you're also identifying some of the resources that are necessary to support you. So starting off in the implementation part, we'll go into the privacy governance, which is developing those artifacts, policies, procedures, the structure in terms of the personnel that will support, and then drive the operationalization of the program. So that is enabling the whole program to operate. We implement the items that we've developed, get persons on board, and prepare those artifacts that are needed for submission. When finally we do a quick check to see if everything is in order, and then we register with the Office of the Information Commissioner. And don't worry, folks, we're not going to just leave you right there with the high-level items. Let's talk about what the key activities are. In the current state assessment, that environment review, this is where we're getting a full understanding of our environment. Now, the great thing is that with the persons on this call today, if you're the one leading the charge for your organization, a lot of this work is already done. You know what your organization does. You have a great understanding of where the information is, and you understand what some of the gaps are right off the bat. But that being said, we should formally document this so that we are aware where the measurements fall short and where the things are that we need to improve. So some of the things that we're going to need to do is we're going to have workshops and conduct interviews with some of those key stakeholders, particularly departments that are interacting with personal data. And that could be from a collection standpoint, that could be from a processing standpoint, and even through to records management or destruction. As well as you're going to need to talk to some of the technical teams who are going to tell you who are going to answer some of the questions like, where does the data sit? You may have a cloud environment that a lot of business users may not be aware of. So you'll talk to the technical teams like IT to say, okay, for this cloud environment, where does it actually sit? Because we have to consider things like jurisdiction in our requirements. For anybody who has made sure to read the legislation at night, and particularly to put yourself to sleep, you'll be familiar with the various standards for processing data. And I believe it is standard 8 that speaks to not sharing data to a jurisdiction that does not adequately protect the rights and freedoms of data subjects. So that's why we need to know where our data is. And we have to raise that with the persons who know where the systems sit. So think about, of course, marketing team, because we want to know whether they are doing any direct marketing activities and how do they go about creating those campaigns and ensuring that we have consent to do direct marketing. Customer service, of course, because they may be some of the persons who are interacting with data subjects on a day-to-day basis, whether it be over the phone, email, in live chat box, live chats, et cetera, et cetera. Legal, risk, and compliance. In some instances, this may be one department, it may be multiple, but they're of course going to assist us with making sure that we have complied with the legislation, as well as we are not overstepping on any other requirements that we have from a legal matter. So we're not going to immediately change the third-party contracts that we have in place if we see any gaps. We're going to talk to legal about what does it mean to amend this for a future agreement, or can we renegotiate the agreement in order to make sure we're addressing data privacy in our contracts with third parties. Number two, of course, inspect all the policies, procedures, because we're not going to throw what we already have and start anew. If we have an information security policy, for example, there are going to be some things that are probably already addressed, and we want to check those things off. You know, do we have requirements for encryption of data? Does it specify what type of data and where? Do we have requirements for access control mechanisms, and does it include things like least privilege, so that we're already inputting into our systems a way of managing the type of access people have, not just to other data, but to personal data as well. Is personal data covered under our data schemas, and do we have a data inventory or a record of this data? So we're checking to see that all these things are in place, and whatever is not in place that's going to help us to meet our end goal, we can mark that off as non-existent at the moment. And then finally, map the legal requirements to how we're using personal data. And I say this because in some instances, you may find that your organization could be exempt from particular parts of the legislation. We're not going to be exempt on a whole, but there may be certain things that we're exempted from. For example, depending on the type of research that you may be doing, if you're publishing this data in an aggregated form, then there are certain things that may not necessarily apply to you under the legislation. But of course, we're not going to take a blanket approach as saying everything applies to us or everything does not apply to us. Next, we want to talk about the desired outcomes. And of course, what we want to get at the end of this process is have a high level understanding of what's in our environment and what we need to do. Sorry, excuse me. So we want to develop an initial list, and this really can be at a high level to say, we are collecting demographic data, accounting information, medical information for our employees. We may end up saying for our customers, we are collecting X, Y, and Z at a high level, because we want to be able to understand very quickly, because we have to move quickly now, very quickly what may apply to us, yes or no. From there, we'll have a clear understanding of our collection mechanisms, and you may even start the process of data mapping in this phase. But the amount of time that we're putting to this is definitely not enough to complete all the work. Then we want to do an understanding, of course, of the applicability to our environment. And that's important, because what we want to show to the executives or to any of the teams that we need buy-in from, this is what all of what we're doing means in terms of applicability to the legislation and what it could mean if we are not compliant, because that is still an overarching kind of cloud to say, listen, we need to get right with legislation. Then we go on to do a gap assessment. Oh, and apologies, the previous screen, we estimate about 2 weeks for that first point, and that of course may vary depending on how much time you can dedicate. But if you're a resource that is leading on this effort, then you may estimate 2 full weeks of trying to get through that process, because we need time, of course, to schedule meetings and have discussions and go through the documentation with the personnel responsible for doing a lot of these things. Then we're going to go on to the gap assessment. The key activities here are, it's like an audit, but I don't want persons to get afraid and say it's an audit. So it's not quite an audit, but this is where you're actually taking all of the requirements and saying, this is what we're doing in order to meet this requirement, and specifying what the gap is in order to develop a unique recommendation to state exactly what needs to be done. So if we've looked at the information security policy and it is addressing majority of what we need for data privacy and protection, then you may identify just a gap that is saying we need to be clear about including data privacy as a part of assessing third parties before giving them any access to our data. So there may just be statements missing from our policy. It may be that we have to just develop a whole privacy policy because the information security policy only addresses information security. And that's what this part of the assessment is for. One of the things you can use to help guide that assessment are some of the recognized standards around data privacy, which are ISO 27001, which is the Privacy Information Management System, which is an extension of the ISO 27001 for information security management. I hope I'm not confusing anybody. Or you could use another recognized one called the NIST Privacy Framework. Now, the NIST Privacy Framework is really great. Both of them are great, and I would not pick one over the other per se. Why I would probably say a lot of persons can quickly go and use the NIST one is because it's free. You can just Google search NIST Privacy Framework, and you'll find the whole framework available to download. That means the only risk you're having to using it right now is the space that it takes to download it on your computer, or the time it takes to go and download it. Whereas the ISO, as great as it is and as extensive as it is, you would have to go and buy the standard to be able to use it. Now, why I say you can use this, even though we're already looking at the legislation, is that you can map the requirements of the legislation to the NIST Privacy Framework or to the ISO 27001 framework. Because what these frameworks provide you with is, it's a control included may say, or actually does say, data is deleted when it is no longer needed. Now that maps directly to one of the standards, and I can't remember the standard number right now, but it maps directly to one of the standards within our legislation, and you can treat it the same. The reason why the frameworks work pretty well is because you can use that as a guide to your whole program. So you can use all of these definitions to help develop your future state and manage your program that way. And as I said, they're not tied to any one legislation. So, they're here to be robust, and they get updated on a regular basis, so we can continue to improve our program as well. Secondly, develop maturity ratings and recommendations based on gaps identified. Now, we're pretty new to privacy in the region, not just Jamaica, but the Caribbean region as a whole. So you may not be able to quickly grab, certain maturity frameworks like CMMI to determine what maturity level you are, because that's going all the way to optimize at the top, where optimized is we have been doing this on a regular basis, and we are continuously improving. Most of us are not going to be able to say that. So you may develop a more customized, set of maturity ratings to yourself. I tend to use, 0 is non-existent. We haven't been doing anything at all the way to active, meaning that we meet this particular privacy requirement, just to kind of scale and see where are our biggest gaps, and it helps to just have that color scheme. You could just use a 1, 2, 3, 5, 1, 2, 3, 4, 5. And there are other frameworks such as MITRE, M-I-T-R-E, that has privacy maturity models that you could look at. Then we're going to prioritize the gaps and create recommendations based on the significance of the need to meet our obligations. And some items are going to drive others. So from the get-go, we're going to have things like the privacy policies and procedures that may help drive things like our data protection impact assessment, because we're going to need a framework or an approach to doing the data protection impact assessment. We're going to need to assign it to specific resources. So we're going to put all those things in our policies and procedures. And then, further down the line, probably in like June or July, we're actually going to execute the data protection impact assessment based on the policies and procedures that we've developed, and using the personnel that are assigned to do it, because we need to get into the habit of doing these things so that it can be done again the following year and the year after that. So that's part of helping to operationalize the process. And from this, we're going to have, of course, a clear understanding of what our gaps are in the current state, and what our privacy and what our levels of maturity are. And this we can estimate about 2 weeks. It may take another week or two, depending on, again, on how available persons are to meet the requirements. Now, I think this is a fun part, the implementation plan, because this is what is really going to determine how we move forward from here. We've identified the gaps. We know what the biggest issues are. We have most likely identified the resources that we need to support us. So we're going to develop our future state definitions and governance models. One of the models that I tend to use is very similar to our 3 lines of defense. So we'll start with the team or the personnel who are on the ground. That's the first line. They're going to execute on data privacy on a day-to-day basis and help advise organization. For bigger companies, and I know there are persons on here that are from bigger organizations, you may recognize them as similar to like your risk liaisons, where you have a centralized enterprise risk management department who leads from a central point, but you have risk liaisons who are there to assist at the unit level or the project level. And that's kind of how your data privacy liaisons or stewards or champions, that's how they're going to operate. Your second line of defense may sit more as a privacy team, and that could also be the team that is leading the actual implementation. They're going to oversee the development of the policies, procedures, artifacts, all, everything that is needed. And of course, report upwards to your third line of defense, which is your oversight committee, the people who are there looking and checking to see what needs to be done. You're not working on operations day to day, but they are there to help oversee what's happening and do reporting. So, still somewhat independent, but, so not, I'm not trying to say that this is a one-to-one match for the 3 lines of defense, but, I'm thinking about it in those 3 layers, because really and truthfully, your full third line is going to be, of course, still audit, who sits separately. So internal audit and your data protection officer, but, design a framework or a structure using things like ISO or NIST to be your, what oversees your controls and processes. You can use, make sure it includes what technology you need. And then of course, the structure is there to guide what people you need and where they need to sit. So again, in these key activities, you can recommend a framework for adoption. That can be the ISO or NIST. There's another one that I like, and you can find this one online as well. It's called NIMITY. So you can feel free to look that one up. This can piggyback off of what you already started to use for your gap assessment. We've used this framework to assess ourselves. We've created recommendations based on that framework. So we're going to move forward and implementing this framework as a means. Doesn't mean that you have to get certified for them, but it's just, this is our guide that we're going to use. And then develop that roadmap to 1, implement what's not there, and 2, to remediate any other gaps. And that timeline can vary depending on the size of the organization, depending on the complexity of what you're doing. Group of companies that have multiple different types of companies versus a single type operation that all your data is being collected either online or by persons who walk in through the door. That's going to require a different level of effort, because one of the things that we know we have to develop, of course, is our data mapping in order to get our record of processing activities. And what are the desired outcomes from there? We want what is the suitable framework to guide our operations. We want to have a clearly defined future state so that we know what we're working towards, and then the roadmap that's going to take us there. And that could be 2 weeks to develop. All right, implementation. And I think this is where everybody needs to be, very soon. So, we're looking at hopefully by January, February, the latest, we should be at a point where we're really starting to implement what we need to implement to get us there. So we're going to develop the policies and procedures that are needed. That includes things like our privacy notices so that we can start pushing them out to the different platforms, because your privacy notices are not going to only be at your front desk where you're interacting with data subjects or customers. It's also going to be a part of your HR policies. It's also going to be on your website so that people know where to find information about how you're processing and how they can act on their data subject, right? So we start that process as soon as possible to get it out there, and updating some of the existing stuff like our risk management framework so that we're addressing things like our privacy impact assessment and data protection impact assessment, because it probably will fall a part of that framework. Develop, the other program documents to help, manage the group. So, that could be your project charters or your committee charters for your, as I explained with those 3 levels, to oversee the teams or the committees, and responsibility matrix to start getting persons on board. And you want to do this early, of course, because we want to be able to communicate to the persons that we are that we're bringing on board as a part of this journey within the organization, we want to communicate what is expected of them. So you can develop a quick and easy way to do that is develop a responsibility matrix that indicates, well, you need to be informed, this person is going to be accountable, this person needs to actually action the item. Develop the data inventories, maps, and classifications. And I think this is where I get a lot of questions on how do we actually do this. Now, there are some templates that you can find online. If you go to ico.org.uk, you can find some templates on there because that is one of the bodies that assists with GDPR oversight in the European Union. So there are some templates that are available there. I do think that we will get some here in Jamaica, depending on when the regulations come out. But I'm expecting that they'll be pretty close, So you can look on there for things like, what's generally included in a data inventory. The data mapping is a little bit different because the data mapping is really just saying, this is the type of data. So we have demographic data that starts at the customer service desk, that gets uploaded to an electronic system. That system saves it to this database. That data gets replicated here. So you have to show how the data moves because we're going to use that to identify what are the points of risk for the data throughout its life cycle. So that's why we're developing some of these items early in the process because they're going to help to develop some of the other items necessary, like being able to perform the data protection impact assessment and the record of processing activity that we'll need for submission. And then, of course, we have to sensitize everybody. So we're not going to only develop the roles and responsibilities or the terms of reference or the charters and just say here. It is now ready to go and everybody, it's all going to magically work. We need a process for sitting down and sensitizing the person about their roles and how does this, if there are any, how does this change how they operate on a day-to-day basis? So, again, having a policy means nothing if people don't know about it. So we have to develop all these artifacts and sensitize the relevant personnel about it. And of course, the desired outcomes from this is that we have the right artifacts in place, policies, procedures, terms of reference, responsibility matrix, any other documents that may come up as unique to our environments, such as, if we need to have specific standards for things like encryption, etc. You develop all of those and have them ready. And then, of course, you mobilize the team who are going to be a part of this full rollout. Because we're going to bring our champions on board from the, the business unit level or the business entity level. We're going to bring them up, sensitize them, and we're going to help roll this out to the rest of the organization. And this could take some time. I can tell you for sure, procedures take a while to develop because this actually requires meeting with the persons who are doing this on a day-to-day basis and creating enough steps that they can clearly walk away and do this same process again without any other intervention. So we have to be clear about the steps included in procedures, and that may take a couple of weeks to really refine. Again, while we're still on implementation, of course, is operationalization. We want this to be working in a way that we can measure. And they say, if we can't measure it, then that means we don't need to do it. I can't remember the exact quote, but something along that lines. So we want to operationalize it in a way that we can continuously measure our performance and see what needs to be adjusted. Key activities include, of course, implementing processes to manage the metrics and oversight. And if you're not so sure what metrics you could use, there are things like, how many PIAs have we performed? How quickly do we respond to data subject requests? So, if we want to measure that and we haven't been doing it in the past, then we may need to implement a log or a way of tracking how many data subject requests do we get? What category of data subject request is it? Is it a request for access? Is it a rectification? And a way of closing that log so that we can see how long did we take to addressing the data subject request. Do we get continuous requests on the same thing? And you measure these items because you want to know where to focus. And that's an example of a metric that we can include. You may include things like cybersecurity type statistics to see how well they're protecting personal data where it exists. So how many audits have we done? How many penetration tests have we done? How many vulnerabilities have been identified from the penetration test, and what is our rate for closing those? Of course, we want to bring on board our DPO and sensitize them. We're not just talking about bringing them up to speed on what their role is, but also how do they fit into the organization and what are some of the things that we need to keep them in the loop on. Are they going to be a part of our data privacy committee's regular sessions? Or do we have a mechanism for reporting to them on a regular basis so they are aware of what's happening in the environment? Because remember, we have to provide a way for the data protection officer to perform their role. And finally, conduct a data protection impact assessment. So by this point, we would have a good understanding of everything that's in the environment, and we will have started implementing controls that are necessary. For organizations that haven't done so already, you may even include in this point a security assessment. And it could be that you have internal persons do it if you can prove that they're separated and can be, and give an independent or realistic, an unbiased view of what's in place. Or you can have a third party who does it for you and give you a report. So at this point, because this is again to test the robustness of our systems. And lastly, the desired outcomes from this, of course, is that our program is operationalized and we understand how to measure its performance on an ongoing basis in order to meet our rights on a continuous basis. And again, as light as it may sound, this could take approximately 3 to 4 months. A privacy impact assessment by itself, and a privacy impact assessment is done whenever we have a new project or a change in processes. One alone, depending on the complexity of the project, can be two to 4 weeks, could even be 6 weeks, depending on how complex the project is. So you can imagine trying to do a data protection impact assessment for your entire organization, where we're trying to understand, here's all the data we have, here are the protection mechanisms, identifying each risk, identifying what is the control that we have in place to manage that risk. This could take 1 to 2 months, depending on how quickly and how available information is. And finally, very simple, is of course to check and do your registration. So we're going to double check the documents that we need. You may want to get another opinion. You could get internal legal counsel to review it. You could get a external legal person to take a look. You could get a third party in general to take a look, just to kind of cover off and give yourself that added piece of assurance. But if you're doing it yourself, by all means, that's fine. Just double check that you've met the requirements under section 16 of the legislation and section 45, which covers the data protection impact assessment. I'll repeat the numbers, section 16 and section 45. So, lastly, we want, as best as possible, establish communication with the supervisory authority. And in our case in Jamaica, it's with Ms. Celia Barkley and the information, and she's the information commissioner in the office of the information commissioner. And why do we want to establish communication? It's because we want to have a good relationship. And we want to make sure that we can call on her for advice when necessary, in addition to the advice of our DPO. But we don't want to have a case where she's calling on us because she doesn't know what's happening, or things need to be addressed that we didn't realize are happening. And the desired outcome, of course, is that we've done our registration, we're good to go. We appear on that public register of data controllers. And finally, we have a line of communication with the supervisor authority that we can call on. So you may even develop potentially procedures for managing that communication on an ongoing basis. And we estimate about 1 month for this process. Where do we go from here? Immediate next steps. Depending on where you are in your journey, and we did that quick survey, and we know most organizations are still trying to get moving. Start off with sensitizing leadership. I've heard quite a few conversations from whether it be IT personnel or compliance personnel who have said, well, I know this is important, but our leadership hasn't really bought into the idea yet, or persons think the effort is not as big as it is. Given all of that we've discussed today, I'm sure most persons on this call will say, yeah, we have a lot of work to do. So of course, sensitize leadership and get that buy-in. So you can use the same checklist that I provided, say, these are items that we know are missing at a high level, just to make it quick, or these are things that we know have in place and these are what we need to fix. Communicate the importance of non-compliance. We know that there are some fees, big in some cases to some organizations, depending on what that 4% means to you. But more than anything else is the reputational damage it could cause. We've heard of breaches in the past, and in Jamaica, the news travels quickly, so we know what trust can do to our operations. Just today, I won't swear by it, but just today we're hearing news that there was a potential leak of phone numbers on WhatsApp. Those things can be scary to people. If some persons heard it and immediately thought, all my business gone out the road, all of the chatting WhatsApp, not knowing that the leak has claimed to really just be your phone number getting out there. But it does mean that we have to be extra vigilant. And should WhatsApp now notify us within 72 hours? I think they should. And they could be impacted by legislations like GDPR if that really has happened. Estimate the effort and the support needed. So it's not, this is an organizational-wide project. This is not just going to be just compliance. It's not going to be just IT. It's not just risk management. This is going to be an effort from multiple units or businesses. So for example, when doing your data protection, when doing your record of processing activity, you may break that up into different parts, send it to the different units and ask them to fill it out, or conduct a workshop with them so that they understand how to complete it. And then your job as a lead may be to put it all together and double check it to make sure this makes sense and it has captured everything that we need to. We're going to mobilize the relevant personnel based on our action plan. And then finally, get started with your current state assessment. If you're past that, of course, then use what you understand to be the gaps to drive your next steps forward. And before we hop into the questions, I do have another quick poll for you all. So I asked my trusty sidekick to launch that poll. But based on where you are today, do you think you need support to get yourself moving? Yes, no, or probably you just need to you need to get some more conversation. So you can take a second to think about that. And I'll give it about a minute before we close that poll. All right, and the polls are in. And the majority of persons that have responded said, no, they don't need support to get things moving. So that's great. That means that you have everything ready to get going. Some persons, about 20%, have need further consultation to decide. And then yes, at 33%. And I understand that the best answer may not be there for you, but you dropped it into the best choice that you have available. So thank you for the responses. All right, I just want to provide a quick overview, of course, though, that Symptai is here to help as needed. We offer from the point of doing the assessments, including legitimate interest assessments through our third-party support, Carter Lindo, attorneys at law, as well as being able to assist with your DPIAs, your audits, etc. We can help you with implementing your program and doing the governance and strategy that's needed. We can act as your data protection officer. So I know one of the questions that I get asked a lot is, where do we go to find somebody? And the truth is, it may be pretty hard to get one person that can act as your data protection officer today, because not a lot of persons have had the experience over the years of working with privacy legislation, with having the technical understanding, with doing risk and being able to assess risk, with being able to do audits from an independent perspective. And it's very hard to appoint someone internally because we need to ensure that they are independent of the operations, because they do need to provide an independent view of what we're doing. So, Symptai can offer that if you need to appoint a data protection officer. And of course, we have training and awareness. And that's not just from a certified perspective with you all who attended the certified trainings, but we can do customized training, do privacy awareness, and we do have an on-demand training, which I do want to provide. We do have a special offer for all the participants here today. Along with the material that we've gone through here today, we do have a quick offer. So, to help sharpen your understanding of the legislation, we are offering a course, or free course, to select respondents. The course covers, of course, Introduction to Data Privacy, overview of the Jamaica Data Protection Act, the rights of data subjects and others, data controllers and processors, what are your requirements, and then data protection standards. So this is going to be free, available for 90 days, and of course, one per person. How to qualify, very important, and it's not automatic. Very important, send an email to training@symptai.com symptai.com, expressing your interest in doing the course. Email used must be the same as the one that was used to register for this course. And the first 10 names will be given access to the course for 90 days. So I don't want to distract you from what we're doing here today, but you might want to hop on and submit that email to training@symptai.com right away. While that is up there, I will go ahead and look at the questions in the chat. All right. First one, how do you ensure independence for a while in regards to the independent security tester? Yeah, it's a tricky one because there are a lot of instances where persons may say, well, we can't bring in an independent third party to do assessments. So what I can only offer is if you have a team of 2 or 3 IT persons, one does have potential skills in information security, or at least a willingness to do the research, learn, and take a shot at it. Then that person, let them sit independent, let them sit separate from your operations. I know what you're thinking is, but they did all this work so far, so we can't consider them independent. But we're just trying to figure out what best as possible. Give them a framework to work with, and I can recommend the frameworks from OWASP, of course. Let them sit on a network separate from your own and do some testing. Try to see what they can get through with. Of course, it's not going to be a perfect measure. I think one of the best things is to get a third party. But if you need to get something done right now, then doing something is better than nothing. So it is hard to really get that full independence from an internal team because they're the ones doing all the work. But probably separate them for a little while, give them a set of checks to follow, and let them sit down and go through it and be honest about what the results are. All right, next question is, what happens if a company doesn't register with the ICO? And that's a great question. The legislation says that the Information Commissioner could ask you to start processing and launch an investigation. Not in those exact words, but the idea is you could be halted from doing your data processing. Of course, it's not on hard and fast. You may be subject to instead a fine or potential jail time. That could be more at the executive level if persons are aware of their responsibilities and are not acting on them. But given that this is a first off for Jamaica, the scenario really is going to play out when we do see some companies that don't register on time. But the legislation does provide that persons could be asked to start processing for the Information Commissioner to do an investigation. A number of companies use overseas data centers for DR sites. What are the implications if these jurisdictions do not have a data protection regulation? Great question. And we've had quite a few conversations with companies in this particular situation because they may have not just a DR site, but backup just goes to the US. And the US doesn't have, for example, a federal level data protection legislation. Now, that being said, the immediate response isn't let's pack up everything and move the data from the US. It is understanding what does the third party that you use have in place to protect information that is stored in the US. So for example, I know I've seen statements from Amazon indicating that they'll move the moon if they have to prevent things like the government from being able to access data in their jurisdiction unless it is completely mandated by a court. So they'll push and defend as much as possible to prevent sharing data to, for example, the government under things like the Patriot Act, and they'll only share the data that is requested or needed to process a legal matter if needs be. But that being said, if you're storing data in another jurisdiction that completely ignores the rights and freedoms of data subjects, then that's where the concern would be. So if you're storing the data in a jurisdiction that says the government at any time can use this information or private organizations may be able to access it, that's where the concern would be. I can't think of an exact scenario right now, but the important thing is to know where your data resides and understand what are the controls in place to protect the data where it exists. I have another question here. Can the DPO be an existing internal staff member? For example, if there is a chief privacy officer, can that person be appointed as DPO as well? And that's a great question. Now, the trick here is, or the thing to note is your CPO going to operationalize or manage the operations of data privacy or any other operations within the organization? And if so, then I would say your DPO has to be separate, because just like the question I was asked earlier about how do you get independence with the security personnel, is you can't have the same person who is implementing controls give an independent opinion on the operation of those controls, because the DPO has to be ready to provide, to say, these things are working well, these things are not working well, and to recognize any gaps that need to be reported if necessary. So if your chief privacy officer is really operating in an oversight role, they're just observing what's happening, they can give an independent opinion, then fine, yes, they could be the DPO. If not, then if they're being operational, then no, you'd have to have an independent person. I hope that helps. So with that, I think we are good to go. And thank you all for joining today. I hope you have a great rest of the day and a great rest of the week.